Hi everyone, today we will discuss an important workplace topic, wrongful dismissal. If you're an employer or employee, understanding the legal framework for dismissal can help avoid unnecessary disputes. In this video, we'll go through MOM's tripartite guidelines on wrongful dismissal, discuss real-life examples, and share tips to navigate these situations. First, what is dismissal? It's when an employer terminates an employee's contract of service, either with or without notice. Wrongful dismissal occurs when an employer terminates a contract without just or sufficient cause, violating the Employment Act of Singapore. While both employers and employees have the right to end the contractual relationship, disputes often arise when the termination is perceived as unjust. This is where the Tripartite Alliance for Dispute Management steps in to mediate such disputes. Under the guidelines, dismissals fall into two categories, legitimate and wrongful. Let's break it down with examples. Companies may terminate an employee without notice for serious misconduct, but this requires a proper inquiry. When I say without notice, I am referring to firing an employee on the spot for very serious misconduct. Let me give you an example. A preschool teacher was fired for hitting a student. The school conducted an inquiry, gave the teacher a chance to explain and establish that there was misconduct. This dismissal was not wrongful because hitting a student violated expected standards. However, if the school skips the inquiry or fails to substantiate the misconduct, the dismissal would be wrongful. Dismissal based on poor performance must follow proper documentation and notice periods. For example, a warehouse assistant consistently underperforms despite warnings and documented reviews. The employer then dismissed her with notice, citing performance issues. This dismissal was not wrongful, as it followed proper procedures. Without performance reviews or documentation, dismissing an employee for poor performance may be deemed wrongful. Generally, companies can terminate contracts by giving the required notice stated in the employment agreement, or if there's no employment agreement, then under the Employment Act. And such dismissals are generally presumed not to be wrongful. Let's say an employee was terminated with the requisite notice under the employment contract, and the employer cited no reason. Since the dismissal adhered to the terms of the employment contract and no evidence suggested ulterior motives, it was not wrongful. Dismissals with notice can still be wrongful if the reason violates the law or is discriminatory. For example, if an employee is terminated based on age, race, gender, or religion, it is wrongful dismissal. Let me illustrate this. A company fired Peter with notice under the terms of the employment agreement. No reason was given for his dismissal, but Peter later reported that the company's managing director had made numerous discriminatory remarks about his race, stating that he preferred to hire someone of another race. This was confirmed by other employees. Even though the company dismissed Peter with notice under the contract, the company's conduct showed that it adopted a discriminatory attitude towards Peter. Taken together, the facts support the conclusion that the company dismissed Peter because of discrimination. Therefore, the dismissal was wrongful. Terminating a pregnant employee in order to avoid paying maternity leave benefits is wrongful. Also, dismissing an employee in retaliation for filing a complaint with TADM or exercising a legal right, such as refusing overtime, is also wrongful, even if the required notice is given under the employment agreement. Now, let's move on to redundancy. Redundancy occurs when roles are no longer required due to restructuring or downsizing. Termination on redundancy grounds are not wrongful if valid reasons are provided. For example, a bartender was terminated after a restaurant cum bar shifted focus to food services. This was a legitimate redundancy dismissal, as the company was indeed changing its business model and no longer needed the services of a bartender. If you believe you've been wrongfully dismissed, one thing you can do is to gather evidence. document conversations, emails, WhatsApp chats, and any discriminatory remarks. Number 2, file a complaint. You have to first submit a mediation request to TADM. You can log in with your SingPass on the website. Step 3, if mediation fails, file a claim with the Employment Claims Tribunal. You can watch my earlier 2 videos on making employment claims under the Employment Claims Tribunal. Employers should document reasons for dismissal and follow due process in order to avoid disputes. Understanding the fine line between rightful and wrongful dismissal is key to maintaining a fair and harmonious workplace. The tripartite guidelines on wrongful dismissal provide a clear framework for both employers and employees to navigate these issues. That's all for today, folks. Thank you for watching. Don't forget to like, share, and subscribe, and I'll see you in the next video.